Welcome to this lecture on artificial intelligence and administrative law. As in so many other parts of society, artificial intelligence brings both opportunities and risks, and this is true in relation to the work of public authorities as well. Citizens want public services to be fast, effective, and easily accessible. And this is also reflected in legal instruments related to good administration, both in national law and European law, and to some extent on the international level. Automation of work procedures of public authorities can contribute to fulfill the goals in these legal instruments. Administrative procedures can be faster, more efficient, and easier accessible from home. And risks of corruption and abuse of powers could also be eliminated when machines are programmed to only consider objective facts. Such automation of administrative procedures can be aided by AI technology. It can handle a multitude of data points and independently discover patterns. So AI gives us the possibility to automate increasingly complex tasks. This, in turn, can contribute to fulfill both social and legal demands of good administration. For example, there are now programs that aim to assess the need for social care for children based on several key data points. And according to some evaluation, these programs seem to be more effective than humans. However, in practice, there are several challenges to the implementation of AI technology in administrative law. Many of them come from the basic structure of the machine learning technology. Its advantage, that it can independently discover correlation in huge datasets, may also become a disadvantage. It becomes difficult to predict the outcome beforehand and to give exact reasons for the results. One kind of problem is that correlation don't necessarily reflect normative relations. For example, an AI application may be trained on a number of previous decisions from a social insurance agency, and may then see correlations between approval rates and certain groups of people, such as disability benefits to people having a certain medical condition. But these correlations may be the result of biases of previous human decision makers, not correct application of the rules. In this way, the AI application may repeat and even magnify existing false stereotypes. And since the result of AI is dependent on a large number of correlation, it is often difficult to describe exactly which data point that were most decisive. In fact, the more advanced the models that are used to represent statistical correlations correctly are, the more difficult it is to describe the role of each single data point. Therefore, there is a risk that both biases and other flaws go unnoticed. More generally, it becomes difficult to give the citizens reasons to the administrative decisions, and thereby to live up to the good administration standards. So, we don't exactly know how AI systems work and how they make their decisions. So how can we be sure that the decisions that they make are fair? From an administrative law perspective, these are key aspects, since the law must ensure that administrative authorities make fair and transparent decisions. A second kind of problems with AI technology in administrative law relate to the lack of human participation in the administrative process. One aspect of this is that it may be difficult to hold anyone responsible for inaccurate results. Another aspect is that it may be an important part of the administrative process to ensure citizens that other human beings really listen to their problems and their arguments. A third kind of problems with AI relate to personal integrity. How much information about the citizens should the government collect and analyze? And how far should the government go to try to use such data to influence, nudge, or even manipulate citizens? So, AI does indeed raise several concerns in relation to administrative procedures. And this has also caused decision makers to issue policy documents. So there are now such documents highlighting various kinds of concerns on national level in many countries, as well as on European and to some extent international level. However, the question of how these problems highlighted here should be solved is still largely unanswered. Therefore, every use of AI must be evaluated in detail in relation to the law applicable to the particular area of administration. The EU General Data Protection Regulation, the GDPR, is of course important. It contains many general rules on personal data processing, and Article 22 of the regulation also set up specific requirements for when automatic decision-making is allowed. In addition, other parts of administrative law must also be analyzed, for example regarding decision-making processes and obligation to give reasons for decisions. So, public authorities that want to use AI face several difficult administrative law problems. Many of them relate to difficulties to control and explain exactly how AI applications work. However, you could argue that the same is true for human decision-making. Even if an AI application is not perfect, it may be as good as or better than human decision-making that is notorious for biases and all kinds of other flaws. As long as the result is better than human case handling, perhaps you could argue that some shortcomings are acceptable. AI definitely has the potential to improve the work of public authorities in many ways, but only if it can be implemented in ways that live up to the principle of good administration in an acceptable way.